hari tu kita dah cover kan the first condition, right? The first element. Okay. So kita nak tengok dia punya section pula. Next slide. Okay. So when you talk about Iqrar, you tidak boleh lari daripada bercakap pasal section 18. Okay. So under section 18, these are the conditions of the Iqrar where it is not admissible. Earlier on last week, last Tuesday, kita dah cover, we have covered for the conditions for Iqrar to be admissible, right? Okay, dia punya syarat-syarat dia semua lah. So in these circumstances, Iqrar is inadmissible. Okay. Subsection 1A is when the Iqrar of the person who is not akil baligh. Okay. Number 2, if the Iqrar is made by a minor. Number 3, if the Iqrar C is Iqrar of a lunatic or a mentally retarded person. Okay, D, Iqrar of a wali or guardian made on behalf of a person under his custody and responsibility. E, Iqrar which is not made voluntarily. Okay, this is very important and this is a very important point. So Iqrar must be made voluntarily. F, Iqrar of a person who is restrained under any written law to administer his property. Okay, next. Okay, an Iqrar made by a mumayyiz minor who has been authorized by his wali or guardian to carry on any businesses or dealing shall be admissible so far as it relates to business or dealing. Okay, so the rest you boleh baca. Okay, next. Okay, so we'll cover, if you remember in our last lecture, there were several cases I asked you to read. I'm not sure whether you read them or not, but I'm sharing the cases with you lah. Okay, so first is the case of Mokhtar Pangat versus Pendakwa Jabatan Agama Islam Wilayah. Okay, this is a zina case. He was accused of charge for unlawful sexual intercourse, which is zina, under section 157 of the Wilayah Persekutuan Order at that point of time. So he actually confessed. So the issue arose is the position of the confession. Can it be accepted as merely an Iqrar or an Iqrar made by an accused person? Okay. So the question also arose to whether the accused really understood the charge. Okay. Normally in criminal cases, before you make a confession, the prosecution has to read the charge sheet to you. Let's, for example, on Monday, the 1st of July 2024 at 2 a.m. At the Mount Kiara condominium, you were found, you're found in a room with another lady, not wearing clothes and in the position of having sex. Do you agree to this charge or not? So he would have to, the prosecution have to explain to him so he understands what he's being charged for. Okay, so in this case, the accused must really understand the charge that was made against him and whether he is agreeing to that particular accusation, the charge made by the prosecution. Okay, next. Okay, so what the court did was the court referred to the case of Maiz. Okay, the case went for appeal. So the Shariah Board of Appeal referred to the Maiz case before making the decision. So they concluded, you remember the facts of Maiz case, right? He made the confession 4 times. So the court concluded that based on the case of Maiz, there are basically 2 principles that the court has to follow. Number 1, the court must ensure that the confession was made aware. He was fully aware of the consequences, and it was made with free consent, meaning it was made voluntarily. There was no inducement, no duress, no coercion on him. And second is the judge is bound to cross-examine him to make sure that he really understood and he actually did it in total. If you remember the case of, we'll come into that later on. Now I might explain later. Okay, next. Okay, so this is the case of Mokhtar Pangat. Okay, another case, Pendakwa Shariah Perak Ishaq versus Fatima. This is the issue of zina. Ada typo arrow kat situ. So both accused were made confession regarding zina in front of 2 religious officers. So because the confession was made in front of 2 religious officers, the court held it was inadmissible because it was made contrary to section 60 subsection 1 of the Sharia Criminal Procedure Act, whereby you cannot, any confession made in front of the religious officer is not accepted, not admissible in court. Okay, next. Okay, you have another case. Halimah versus pendakwa jenayah Kelantan. Halimah lodge a complaint. Okay. So what happened? Ini cerita seorang wanita membuka aib dia sendiri. You know, orang tak tahu, tiba-tiba orang jadi tahu. Pasal apa? Dia pergi buat aduan. She made a complaint to the religious officer saying that, okay, look, I just gave birth, However, this baby was a result of an unlawful sexual intercourse. See, so she actually made the complaint against herself, and because of that, she was charged for zina, unlawful sexual intercourse. Okay, so during in court, she confessed. She said, "Yes, I commit zina. I commit, but then I was forced to do so." Okay, her partner Osman, he denied, "I didn't do it." She must be wrong. I didn't do it. That's not my baby. Probably somebody else, but I don't agree to the charge. So accordingly, he was acquitted. Okay. Remember the earlier principle? The Iqrar can only bind yourself, the maker, but not the other person. So her confession doesn't bind Osman. So when Osman did confess, he denied, he was acquitted. However, Halima was charged and she was convicted. So she wasn't happy, she appealed. So even her appeal was rejected. Because why? She couldn't show the element of coercion there. She couldn't show that she was being proved to have sex with Osman. Okay, next. Okay, Abdul Razak Osman versus Ketua Pendakwa Syariah Melaka. This is case pasal Homar, intoxicant drinks. He confessed for drinking and then he was convicted. The punishment he received was very harsh. I don't have my act with me right now. Tapi kalau maximum, I tak pasti dia punya hukuman berapa. Tapi kalau maximum in kita punya law, in kita punya act would be, maximum would be 5,000 ringgit. Okay, 3 years imprisonment and 6 kali sebatan. Itu maximum. So mungkin dia dapat yang maximum lah. So he wasn't happy, so he appealed. So when the case went for appeal, the Board of Appeal, the appellate court looked at the judgment of the trial judge, and then the court said that, okay, the basis of the judgment of the trial court was that they looked into drinking intoxicant drinks, is actually a hard and is a very serious offense. Therefore, based on that, they give him the maximum punishment. Okay, tapi in reality, hard, walaupun is hard, tapi the punishment prescribed by kita punya act actually is takzir, because hukuman for hard actually is 80 lashes, right? So in considering that, the court said actually when deciding, the court actually kena look into the maslahah, the reason for the court to put actually takzir as a punishment. And then the court should also consider the confession of the accused. So accordingly, the appeal was allowed, meaning that the sentence given by the earlier judge was actually reduced. Okay, next. Okay, so now kita kena masuk kita punya second condition, which is conditions of the rights of the facts admitted, which is the mukir bihi. Okay. Number one, it should be acceptable and probable by reason or by shara. Okay, in criminal matters, it must be clear and specific. Okay, in civil matters, it can be general without any specification. Okay, I kasih contoh for civil matters, so contoh macam kes Fatah Amin dengan Fazura. Okay, Fazura made an allegation saying that Fatah Amin never give nafkah to her and her daughter. Duit raya also don't give. But she didn't specify how much she didn't give her. She didn't specify, okay, he didn't give me 1,000 ringgit a month. She didn't specify. So it can just be general, as in he didn't give me nafkah, he didn't give my daughter nafkah, just like that. Okay. So number 4, dia kena absolute without any qualification. Dia tak ada apa-apa condition attached to it. Okay. Number 5, it should not implicate the right of others. Iqrar in favor of S during death sickness. Okay, during marad maut. Okay, next. Okay. Hari ni dia punya slide laju dia punya internet okay. Baguslah. Okay, conditions of the person for whom the admission is made, which is mukra lahu. Okay. So the person in favor of whom the admission is made, he must be capable of holding the right and property, must not have waived his right to the benefit of the admission, such as by denying the truth of the Iqrar made. Okay. He must be known even though in form of fetus in the womb of the mother. Okay, this would apply in case of zina. Contoh, for example, contoh macam kes Halimah tu just now tu kan. Ni katalah Osman tu mengaku kan, contohlah dia kata, okay, now she's pregnant, so the judge asked her, is that your baby? And then he said, okay, I mengaku that yes, I did have sex with her, and the baby in her womb actually is my baby. Macam tu. Faham that part lah. So number 4, it is not a requisite that he must be of sound mind or attain puberty. So this is section 18, subsection 3. Okay. Then you can refer to the Majalah article 1574. Okay, next. Okay, this is very important. Condition for lafaz sirah. So kita dah cover the first one, which is the person who make the Iqrar. Keduanya adalah kita dah cover the person to whom the Iqrar is made. Kita dah cover the Iqrar itself. And now is the conditions for the lafaz sirah. Okay, so there must be clarity for the statement. Okay, maknanya the confession itself, okay, must be clear, understandable, which reach a level of certainty. Okay, for Iqrar to be clear, it must reach a level of, kalau macam case had kan, dia kena 100% yakin, which is beyond a shadow of doubt. Okay, so it must be absolute and unequivocal, which confirm the related issue. For example, the case of Ma'iz kan. So when Rasulullah asked him, what did you do? And then he said, I did as a husband would do to his lawful wedded wife. Okay. Boleh? Okay, next. Okay, so we are discussing special conditions for had cases and qisas cases. So number 1 would be adultery. So adultery, how many times do you have to make admission? How many times do you have to make confession? 1 time, 2 times, 4 times? Okay. Hanafi and Hanbali said you must make confession 4 times. So let's say if you make a confession, I commit zina, it cannot be once, it must be 4 times. Okay. So they referred to the case of Ma'iz, where the Prophet avoided him for 3 times by asking him to repent to Allah. And the 4th time, after he confessed, he was stoned to death. So meaning to say 4 times. Hanafi, Hanbali 4 times. Okay, next. Okay. Maliki and Shafi'i, only 1 time sufficient. No need 4 times. If you confess, if the prosecution has already read the charge to you, you understand the charge, you understand the repercussions of it, you understand the consequences of the charge, what are the penalty, you know that if you confess, you might have to pay a fine, you might have to go to prison also, you understand that, you still want to confess. 1 confession alone is enough. No need confess 4 times, only 1 time. Okay. So the authority is based on the nature of confession itself. Based on the case of Asif. Okay, Asif, you remember the case of Unais tu? Remember? Yang remember tak yang I cerita kat you all yang pasal that guy tu, yang dia ni anak orang kaya. Ingat tak? That Bedouin guy lah. Okay, so the name of that guy yang I kata the guy tu dia punya muka. Okay, this guy he's a young lad lah, very orang muda lah, you know, handsome pula tu, you know. You boleh imagine lah muka dia macam muka Fatah Amin kan, very good looking. Okay, so he was the son of a very rich man. Do you know Ambani, one of the richest men in the world, the Indian steel metal guy? Okay, he's like that rich, you know, so rich, you know, he has so much property. So Asif is the son of this rich guy. So what happened? I don't know what happened to Asif. Somehow or other he was caught in an affair with a married woman. He had sex with a married woman. And he confessed to the father, look, you know, I had sex with this married woman, you know. So macam mana? So the father was very upset, you know, it's like macam menconteng arang dekat muka now. So what he did, so they brought the case to the judge lah, hakim tu. So he told the judge lah, look lah, this is my son, you know, he already confessed to committing zina, you know, he's young, you know, I have money. I tell you what, why don't we settle this nicely? I give you 100 camels and 1 servant girl, and you forget about the whole thing. Asim only made one confession, no, Asif ni. So, uh, and then whatever you forget about the whole thing. So the Hakim said, okay lah, thank you for the camel. I accept the camel. However, I still have to punish your son because he committed a sin and he confessed to the sin. So he was convicted for 100 lashes, and he was exiled from that particular area. So the father wasn't happy. Dah lah I dah rugi 100 camels, a slave girl lagi. I dah bayar you kot. I paid you. Why do you have to still hukum my son? So he wasn't happy. So he went to see the prophet. So the prophet said, okay, look, what the hakim did was correct. The judgment is correct. If you came to me, I would do the same thing also. So the decision for 100 plus exile was maintained. However, the prophet ordered the hakim to return back the camel and the slave girl. Okay, so first case settled. So what about the woman, whom he had sex with, that married woman? So the prophet ordered his companion Unais to go to see the woman. Ask her whether she's confessing to the fact that she had sex with this Asif guy. So if she does, you stone her to death. And then when the Unais asked the woman, and then she confessed, she said, yes, I had sex with Asif. So upon her confession, she was convicted. So dia only confess kali je. So based on this authority, Maliki dengan Syafi'i kata a single confession is sufficient. Okay, remember the story from the Bani Ghamidiyah punya ni? Yang that woman, she was pregnant, she came to see the prophet. And then the prophet, then she said to the prophet, oh prophet, I'm pregnant as a result of a zina I met with one guy. So the prophet, I confess I commit zina, so please punish me. So the prophet said, you're pregnant, never mind, you go and give birth first. Then she gave birth, and then she come back later. She come back later and said, prophet, do you remember the confession I made the other day before I gave birth? I told you that I commit zina, and then you asked me to go back to deliver the baby. This is the baby, I delivered the baby. So now can you punish me? The prophet said, you go back first, you nurse the baby. After 2 years, then you come back and see me. After 2 years, she came back. And then she said to the prophet, oh prophet, I've already delivered the baby. I've already nursed the baby. Now she's 2 years old. She doesn't need me anymore. So the prophet said, okay, I'll punish you. So he punished the lady. Okay. So he punished the lady based on her single confession, which was made like 3 years ago. So the punishment was only executed after she finished nursing the baby, which is after budak tu dah umur 2 tahun lah. Okay, okay next. Okay. So ada dua kes kat sini, kes Azmi bin Arifin and Maimun binti Abdullah versus pendakwa Syariah Melaka. So let's have a look at the case. Okay. Azmi bin Arifin and Maimun bin Abdullah versus pendakwa Syariah Melaka. Okay, this dekat kes ni yang penting ni pasal kes zina juga. Okay. Azmi and Maimun were lovers. Okay, that they were lovers. So they had, I tak tahu berapa kali they had sex. Tapi eventually Maimun was pregnant, resulting in Maimun being pregnant. Okay. So they were charged in court for unlawful sexual offences, okay, and sexual intercourse, for zina in court. So the prosecution read the charge sheet to Maimun. She didn't understand. The judge asked her, do you understand? She said, I don't understand. So the judge ordered the prosecution to read the charge again. So when it was read the second time, then only she understood, and then she confessed. She confessed to the zina, to the charge. She confessed, I committed zina. Okay, fine. However, her partner, Azmi, didn't confess. He refused to confess. The judge asked him several times. Then he said, no, I didn't confess at all. No, I didn't do it, Tanya banyak kali pun dia tak buat juga. So, if one person confess, the other person doesn't confess, therefore, the court will only convict the person who confess. Because she totally understood the repercussions of it. She understood what she has to face if she makes a confession. Tapi still she confess. Okay. Tapi however, the guy tak nak confess. Walaupun hakim tanya dia banyak-banyak kali pun dia tak nak confess juga. So dia pun tak kena apa-apa lah. Yeah. Okay, next. Okay. So you have the case of MST Bahan. Okay, dekat dalam kes yang tadi tu, kes yang pasal tengok kes yang sebelum ni. Iman, okay. Kes Azmi dengan Maimun, the court didn't actually emphasize how many times dia kena buat confession tau. The court cuma cakap based on dia punya confession tu dia kena charge lah. Dia kena hukum based on that confession. Okay, next. Okay. MST Bahan. Okay, I've already explained this case in the previous lecture. Tapi I nak explain again, I nak emphasize two principles here. So this is a case of zina, she actually gave birth and then she confessed. Let's say dia gave birth, katalah hari ni 1 hari bulan November, right? Okay, katalah dia give birth di Pavali, 31 hari bulan 10. Okay, dia bersalin 31 hari bulan 10. Immediately the next day, which is today, she went to court, she confessed, I committed zina. So because of that, she was convicted for 3 years. Yang ni punishment dekat sana Pakistan lah. 3 years imprisonment, 30 lashes and a fine for Rs 1,000. I don't know what that is lah, tapi that's the amount lah she was convicted for. So she wasn't happy. She appealed. So during appeal, her lawyers contended that, okay, look, dia baru bersalin kot, how do you expect a woman, after suffering, bersalin ni sakit tau. Yang bersalin normal lah. Tapi macam I dulu, I bersalin Caesar 3-3, jadi I sakit tu lepas. Habis tu, sebab I was under painkiller, jadi I didn't actually face sakit ketika bersalin lah. Tapi kalau dia bersalin normal, dia memang sakit. So you pun, your mind tu kan dalam keadaan sakit semua, dan tiba-tiba you buat confession. So the court said that in that point of time, the fact that she confessed a day after she delivered, her mind was not fit. She was more of in pain rather than actually understanding the repercussions of her confession. Okay. So any confession rendered at that point of time should be taken as untrue and unreliable. Okay. Not in the perfect. So therefore, not fit to make a confession. Dia punya state of mind lah. So accordingly, the appeal was allowed. Okay. Kalau case appeal is either appeal rejected, appeal allowed tu je. Okay, next. Okay. Boleh? Okay, so this is the first condition just now apa? Ulang balik, tengok balik tadi. Iman, tengok yang dia punya slide tu. The first condition tadi. Okay, the number, okay. First condition is the number of, no, sebelum tu lagi. Okay, clarity of statement. Okay, next. Okay, keduanya dia kena buat, it must be made orally. The statement must be made orally. Hanafi kata dia boleh buat written gestures. Written gestures are unacceptable and had cannot be imposed. Syafi'i kata you can only accept admission from a dumb person using sign language lah. Ni artikel 69 dengan artikel 70. Okay, next. Okay, this is based on the hadith by Ibn Abbas. Okay, you remember case Ma'iz tu kan? Okay, the hadith was narrated by Ibn Abbas. So he said during the kan Ma'iz came to see the Prophet 3 times kan, only the 4th time he can punish kan, kena convicted. So the first and the second time now, second and third time, Rasulullah asked him, dia kata, you might have kissed her, or you have embraced her, or you cast at her with lust. Do you know what is zina? Okay, ni Rasulullah tanya apa tu Ma'iz lah. Lepas tu Ma'iz kata, yes, I have such a sex with her unlawfully that a married man does it legally to his own wife. Satu. So Rasulullah ni dia nak tahu tau, betul ke dia ni have actually did the actual sex tu fully, dia buat intercourse tu ke mungkin penetration tapi tak masuk tau. So dia kena tanya betul-betul. So dia pun tanya lagi sekali at another occasion pula now. So dia tanya, did you commit zina with her in such a way until your penis was covered in her vagina? So his reply was yes. So ini menunjukkan how detailed the judge actually has to find out whether the zina actually occurred, whether there was full penetration or not. Because kalau there's no penetration, therefore there is no zina. Faham? Zina tu kena ada penetration. Okay, next. Ni must be capable of penetration, Hanafi dengan Hambali. Muslim, dia kena orang Muslim. So bermakna kalau sekiranya tidak ada penetration, therefore you cannot accept the testimony of a person confessing to zina if there was no penetration. Okay. I pernah kendalikan mana kes lah, tapi ni bukan pasal kes zina lah. Ni pasal kes cerai. Okay, it is very important dalam kes cerai tu to tentukan whether there is iddah or not. So how you nak tentukan ada iddah or not depends on whether you actually consummate the marriage or not. So let's say you never consummate the marriage, therefore there is no need for iddah. Because iddah ni macam a waiting period, 3 moon cycle to make sure that rahim perempuan tu bersih daripada any sperm daripada the husband lah. Okay, this is the intention of actually having iddah. So in my case, what happened was that the couple was married for 15 years, After 15 years, the wife filed for divorce. So I tanya dekat dia lah, when was the last time we had a period? I kata, then she told me bila tak, and then tiba-tiba she told me. Dia kata, Puan, saya tak pernah ada hubungan badan dengan suami saya, tak pernah ada hubungan intim. Yeah, I never had sex dengan my husband. Tapi dah kahwin 15 tahun, kata ya 15 tahun. Tapi ada percubaan, tapi memang tak ada. Tak masuk pun, dia kata macam tu lah, tak ada. So during the court date, the judge asked the husband to lafaz talak lah. So the husband lafaz talak kat wife tu. Sebelum hakim nak sabitkan, biasa bila dah lafaz talak, hakim akan pronounce balik, okay, pada sekian-sekian masa, jam sekian-sekian, talak, pihak plaintiff telah menapaskan talak kepada pihak defendant berjumlah 1 talak raj'i. Talak raj'i berjumlah 1 talak pada dan bermulalah iddahnya so and so. And then sebelum hakim nak cakap tu, cepat-cepat bangun tak, cakap dekat hakim yang Arif kata, pihak defendant kata dia tak pernah disentuh, dia tak pernah ada hubungan seks pun. Ni penting tau, because kalau tak ada hubungan seks, maknanya tidak ada, there's no iddah, So hakim pun tanyalah pihak suami. Suami kata, ada ke hubungan, dia tanya husband ada tak hubungan seks. Lepas tu husband kata, ada, tapi wife kata tak ada. So how you nak tentukan ada dengan tak ada, So macam masa tu it was like macam a heated argument, bukan argument, macam it's like macam imagine kau terpenuh dengan orang tau, and then you kena argue dekat depan mahkamah tu whether they had sex or not. Kita mana dah tahu kan, pasal kita luar-luar tau. So the husband kata, then the husband kata, yeah, they did have sex, tapi perempuan tu, the wife kata no, that there wasn't any sex, at all semua lah. Itu hakim arahkan, okay, nanti kita tangguh ni. So he ordered the wife to buat satu jumpa ONG lah untuk buat examination dekat dia punya vagina, dia nak check ada tak tear or not lah. So after 2 weeks later, we came back tu kan, she showed me the result of the examination daripada dia punya gynae lah. Laporan tu mengatakan bahawa there was a small tear dekat kalau macam dekat selaput darah tu kan macam ada macam kesan kena ni sikit, ada macam koyak sikit dekat situ lah. Tapi dia tak masuk, dia just koyak sikit je macam tu. So I presented the keputusan tu dekat hakim lah. So hakim pun tanya dekat dia, okay, berdasarkan laporan perubatan ni daripada doktor ni, memang ada penetration lah, tak banyak. Lepas tu husband tu kata tak ada yang ni, memang tak ada. Lepas sampai hakim tanya tau, are you sure? Kot lah you punya kepala zakar you bermain-main dekat depan tu, mungkin masuk, mungkin tak masuk, ada ke? Lepas tu kita tak ada yang ni, cakap betul-betul ni pasal apa? Ini mungkin tak masuk habis, tapi mungkin masuk sikit, Imagine kita tengah argue macam tu dekat court depan semua orang, hakim malu, I malu, dan lelaki-lelaki tu lagi pula, nasib kita tahu semua dah kahwin lah masa tu. So it was like something macam, oh. So finally the husband mengaku lah, kata yes memang ada. Mungkin dia punya kepala Zakar tu masuk sedikit lah macam tu. Okay. So bila dah ada masuk sedikit, lepas tu confirmed by the medical report saying that there was not full penetration but a bit, pasal ada macam a bit of tear, you know. So that is considered penetration already. Sebab Hakim kata penetration tidak mestinya masuk habis. Mungkin kepala tu kena sikit, itu dah considered penetration already. So based on that, maka dia adalah edah. Okay. Interesting kan? Adalah edah. Edah dia tiga kali datang suci lah. Okay. Selingan ni. Okay. So sambung kan? Dan Muslim bermakna kalau let's say pasangan dia tu non-Muslim, dia hanya seorang je kena charge. Pasangan dia tak kena charge. Pasal apa? Dia non-Muslim. Kalau pasangan dia buat confession pun, court tak boleh nak terima. Pasal apa? Dia non-Muslim. Okay. Last sekali dia kena buat before the court. Okay. So you can refer to section 17 subsection 2B in the case of Haji Adik. Okay. Remember the case pasal Haji Adik tu? Ingat tak case tu? Ingat? Remember? Ingat tak? You nak I cerita ke you ingat? Kalau you nak I cerita, you cakap you ingat. You cakap you tak ingat. Kalau you dah ingat, I tak cerita lah.
Ingat madam.
So I tak payah cerita okay, ni pasal kes yang orang Sabah tu lah. The Sabah politician yang he spiked the drink of one of the lady nama Rania tu. Okay, next. Okay, so then kita masuk theft dengan hirabah. Theft adalah sariqah. Hirabah ni macam highway robbery. Okay. Apa contoh highway robbery? An example? Ada ke? Tak ada? Okay, highway robbery tu macam contoh lah, macam ni biasa berlaku dekat Melaka lah, diorang cakap lah, dekat jalan yang I think one of those roads kat Melaka lah, you know. Kalau you lalu situ malam-malam kan, tiba-tiba je you punya kereta mesti accident. Pasal apa dong? Ada orang jahat kan, dia letak minyak ke jalan tu. And then tiba kereta you jadi macam accident lah, you know. And then you terpaksa keluar pada kereta. Masa tu lah diorang rompak you. Ataupun diorang letak paku-paku dekat jalan kan, so bila lalu kat situ, tayar you pancit lah kan. Terpaksa keluar kereta. Sebab you keluar kereta, masa tu kena rompak. Ini dalam konteks yang dekat darat lah. Another example would be dekat laut, you know. Macam Lanu-Lanu lah tu, highway robbery lah tu. Jadi dekat sini, the number of confession dekat case macam ni, according to Hambali, Abu Yusuf dengan Zafir adalah 2. You need 2 kali confession. Okay. So jumhur ulama dengan Zahadi kata only 1 confession. Okay. So yang keduanya, dia punya condition dia, the claim have been made by the person whose property is stolen. Okay. So this is based on Abu Hanifah dengan Imam Muhammad lah. Jadi based on the hadith that where the Prophet delayed the pronouncement of the verdict until he found out the aggrieved party who confirmed the confession that has been made. So you hanya boleh, kalau macam kes kecurian kan, you boleh nak charge orang tu, nak terima confession dia provided you tahu orang yang buat confession tu lah is made by the person whose property is stolen. Macam tu. Okay. So Abu Yusuf, he disagree. Dia kata existence of the claim is not necessary since the people normally will not see and true things for themselves. Okay, next. Okay, then you have drinking of khamar. Okay, sini the number of confession kalau ikut Hambali, Abu Yusuf dengan Zafir adalah 2 kali. Okay, so according to it should be made immediately before the smell disappears. So this is according to Abu Hanifah dengan Imam Abu Yusuf. Muhammad Al-Shaybani disagree. Okay, next. Okay, other hudud offences. Okay, maknanya macam apa lagi hudud offences? Judi hudud offences. Other offences lah by a single confession. Tapi untuk qazaf dia kena 2 kali kalau ikut Zahiri. So kalau kisah 1 kali, takzir 1 kali. Jadi you have the similar case Abdul Aziz bin Musa, Harun bin Suman. Okay, next. Okay, This is the effect of Iqrar. Okay, effect of the Iqrar will only bind the maker. What is the authority? Article 78, Article 79 of the majalah. Okay, Maiz punya case, yang case Asif tu, yang the Bedouin guy yang bapak dia kaya gila yang kasih 100 kunta tu, yang dia kata, oh nice, go and find that woman, go and ask that woman, the married woman who Asif had sex with. If she confess, you punish her. Okay. So ni satu case Abdul Wahab versus Timbalan Pendau Mahkamah Syariah Selangor. Okay. Here the accused was confessed of an offence of halwat and he was convicted towards it. Okay. Next. Okay. Effect of the confession on the co-accused. Okay. In criminal matters, dia tak ada effect langsung. Contohlah macam tadi kan, macam kes Fatimah Ishak lawan Fatimah tu kan, that case just now tu, Fatimah confess tapi Ishak tak confess. Ishak pula Osman is it? Yang perempuan confess, laki-laki tak confess. So the confession by the lady will not affect the man. So based on her confession, she will be convicted, she will be punished. But the man, since he didn't confess, therefore he will not be punished or not be convicted at all. Okay. So kita ada hadis by Said bin Said Al-Saidi. Ni dalam kita punya first lecture ada hadis ni. And also the hadis based on Abu Hurairah ni, case ni hadis Maiz punya hadis lah ni. Okay, and then Article 78, Article 79, we have a few cases here. Saif Rahman and another versus the state. MST Safia Bibi versus the state. MST Zubaida Begum. 1, 2, 3 adalah kes Pakistan. Okay, Pendakwa Syari'i versus Hairuddin Haji Abdul. Okay, next. Abdul Ghaffar. Okay, tadi criminal matter, now civil matters. In civil matters, in certain circumstances, it will directly affect the interests of the people other than the confessor. You pernah tengok tak cerita lelaki itu? I think it was viral a few months back now. Yang cerita yang perempuan tu yang dia bercinta and then she found out that actually the husband is actually the brother. Sebab turn out to be that sebenarnya dia punya father tu masa dia kahwin dengan mak dia ni, before kahwin dengan dia punya mother ni, dia ada another wife. Dia kahwin kat Siam lah. And with that wife, he had a son. So he abandoned that family. Lepas tu dia kahwin dengan mak perempuan ni lah. Yang Hana Delisha punya mother ni lah. So diorang dapat Hana Delisha. And Hana Delisha berkenalan dengan this guy ni lah. Unaware that actually this guy ni adalah dia punya brother. And then tak macam mana tak, eventually they found out that the mother, dia punya penceritaan dia, lepas tu dia dapat tahu that sebenarnya yang suami dia ni, masa tu dia dah pregnant tau. She was pregnant and then she found out that actually the husband is the brother, abang kandung. Wish. Sama lah macam ni. Kan? Example dia buat paternity test, confirm that she is the daughter, yang ni example ni tu adik lah, that dia ni the father-in-law is actually her father. So dalam kes macam tu, perkahwinan tu kena difarakkan, dipisahkan untuk selama-lamanya. Macam dekat kes lelaki itu kan, Hana Delisha tu she died kan pasal she was very depressed kan, dia kena berpisah dengan suami dia semua, whatnot lah, macam tu lah. Okay, next. Okay, retraction of Iqrar. Okay, all the jurists agree that you can retract confession even after judgment is given. Example, the case of Maiz. Okay, when after the first conviction, Maiz was the Prophet ordered Maiz to be put inside the ground. Korek lubang, masuk ke di dalam lubang tu, and the throat rejam him with stones. They threw stones at him until he died. Now, during the process when they were like throwing stones at him, he managed to escape. He wanted to run away, but then all the Sahabat went and catch him and pulled him back inside the hole, stoned him to death. So when the thing came up to the Prophet asked, why didn't you let him go? And then the companion kata, why Rasulullah, he already confessed. he committed a sin, so he must be punished. Dia kata, yeah, but then he wanted to, the fact that he tried to run away, meaning to say that he retracted his confession. So you should allow him to go. Macam tu. So based on that hadith lah. So how do you make the retraction? You can either make it expressly or impliedly. Jadi Abu Hanifah, Imam Malik dengan Imam Ahmad kata implied confession is permissible. Syafi'i kata tak boleh, dia kena oral. So kita ni mazhab mana? Kita mazhab Syafi'i kan. So therefore we must follow Syafi'i. Meaning to say that confession according to mazhab Syafi'i must be made orally. Okay. Effect of the retraction depending on the cases. Okay. Rights of individual people cannot be retracted. Okay. Ini contoh macam kes harta pencarian. Okay, reason the right of human being cannot be nullified by doubt as the case of a retraction. So Article 1588 the majalah. So for example macam kisas kan, you cannot retract it as it involves the right of the people. So this is Arif Nawaz Han and the state. That's the case at hand. Okay, next. Okay, so kalau melibatkan hudud, which is the pure right of Allah, okay, you can. Is valid lah. Okay, boleh. So had will be commuted to ta'zir punishment. Tengok yang slide sebelum ni, Iman. Dia punya efek. Okay. Okay, so kalau macam macam dalam kes Maiz tu, you can retract. So dia melibatkan hak Allah lah, which is had in cases. Okay, next. The next slide, man. Okay, thank you. So dia punya authority adalah kes Maiz. The saying of the Prophet when hearing the attempt of Maiz to escape, I wish you should have left him and brought him to me. Macam tu. Okay. So kenapa? Sebab retraction creates doubt. Okay, next. Okay. Ada some circumstances where combination of the right of Allah and mankind. Okay. Allowed, but retraction only removes had punishment. The man's right remains unaffected. Okay. So this is based on a hadith where it is incumbent upon the person to return what he has taken out of other possession. Okay. Ni contoh macam kes mencuri kan. Mencuri adalah the right of Allah kan, sarikah kan. Is a had punishment. However, bila dia mencuri barang orang and they confess, okay, you confess and then you retract your confession. You retract back the confession. But still, okay, the other person punya hak is still there, you know. So you have to return back his barang. Katalah you curi iPhone dia. Okay, you dah mengaku you curi. Tiba-tiba you kata, oh I tak curi pun. Okay. Tapi barang iPhone tu bukan milik you. So you still kena return back the barang to him. Okay. Itu contoh lah. Okay, then you have ta'zir where it cannot be retracted. Okay, Anwarullah kata in case of ta'zir it cannot be retracted. Ta'zir punishment is still enforceable although it has been retracted. Okay. Okay, so in the case Abdul Aziz, the same case just now. Okay, next. Ini case khalwat. Okay, next. Okay, apa isu yang timbul? Contoh macam theft cases, okay. You ada syahadah and then you ada Iqrar. And then you retract balik benda tu. You ada, maknanya syahadah ni bermakna ada saksi. Saksi plus confession. Dan kemudian you retract the confession. Tapi saksi dah ada. So in this case, in case of theft lah, there is no hard punishment since you dah tarik balik your confession tu. Tapi ta'zir still kena. Your mandatory, you kena bayar juga dia punya jumlah value of the property. Okay. Another situation would be, what if after retraction, the case can be proven by way of syahadah. You dah retract confession you. Tapi witnesses tu, syahadah tu boleh prove that actually you commit it. So Zahiri, Maliki dengan Ahmad kata had can be imposed based on the syahadah. Syafi'i kata had cannot be imposed as retraction creates doubt. So kita based on Imam Syafi'i. Therefore, you cannot you cannot impose the had based on the syahadah. Sebab dia dah retract dari confession. Okay. Next. So these are the cases. Nanti kena go through cases ni. Cik Lah versus pendakwa jenayah Kelantan. Faridah versus pendakwa jenayah Kelantan. Pendakwa versus Ahmad Awang Mat Isa. Pendakwa Pegawai pendakwa Muiz versus Haji Adik. Pendakwa Syariah versus Muhammad Zulkifli bin Adam. Pendakwa Syariah Pahang versus Kartika Sri Devi binti Soekarno. Okay, yang kes adik ni you tahu kan? Tahu kan kes ni dah, yang pasal kes yang siapa politician tu yang he spike the drink of this one perempuan ni kan, pasal perempuan ni datang jumpa dia nak buka salon kan. This is the case lah ni. Okay, Kartika Sri ni adalah kes pasal kes arak. She was caught drinking liquor and she confessed. So bila dia confess, dia kena hukuman lah kan. I think this is the first case kot. I mean among the first case yang hukuman terhadap arak sebatan dilakukan in this case lah. Okay, next. Okay, so kita akan kaji now, kita dah settle Malaysia dah settle lah. Now kita cover Iqrar dekat Pakistan dengan Brunei. So let's have a look. Okay, dekat Pakistan is covered under Qanun Syahadah Order 1984. So definition Article 30, oral and documentary only. Jadi any confession made before ni sama juga macam section 16 lah. Before police officer cannot be accepted. Article 38, confession to police officer. Article 39, confession being made whilst he is in the custody of the police officer is not accepted unless it was made in the presence of the magistrate. Similar to section 60 subsection 1. Okay, criminal procedure. Next. Okay, apa dia punya effect of confession? It is stated in Article 43 of the Qanun Syahadah ni. When more persons than one are being tried jointly for the same offence, and a confession made by one of such person is proved, therefore such confession shall be proved against that particular person making it, and the court may take into consideration such confession as circumstantial evidence against such person. Dekat sini confession affects the confessor only, but can be accepted as circumstantial evidence to the others who jointly charge for the offence. Okay. So macam in our kalau dekat Malaysia, kalau you mengaku, you kena hukum. You tak mengaku, you tak kena hukum. Tapi dekat Pakistan, kalau you mengaku, you kena hukum. And then yang tak mengaku tu, dia akan, your confession tu is taken as qarinah to charge the other person. Nampak? Okay. For the same offence, taken as qarinah for the other person. Okay, next. Okay, dalam zina cases, Section 8, Section 8A of the Offence of Zina Enforcement of Hudud Ordinance 1979, dia kata proof of zina liable to had if the confession was made before a court of competent jurisdiction. Sama dengan kita lah. Jadi dia quote this case lah, bahan against the state. Dekat sini, confession must be made 4 times at 4 different sittings, so as that the accused is off the side of the court and away from the police. Okay, or parties pressure before coming back for the subsequent condition. Ini macam case Maiz juga lah. Okay, next. Okay, confession in theft and robbery. Kalau you perasan dia punya susunan tu sama dengan Malaysia kan, kita tengok zina macam mana, theft and robbery macam mana, liquor macam mana. So dekat sini theft is under section 7A of the offences against property, enforcement of hudud, Ordinance 1979. Okay. So dekat sini dia kata the hard punishment can be imposed when the accused pleads guilty of the commission of the theft which is liable to hard. Okay. So dia kena PG kat sini. Confession in drinking liquor. Section 9A of the Prohibition Enforcement of Had, Order 1979. The proof of drinking liquor is to had shall be when the accused makes before a court of competent jurisdiction a confession of the commission of drinking liable to had. Okay, next. Okay, apa effect retraction pula? Okay, retraction is under section 10, Prohibition of Enforcement of Had, Order 1979, where it says that when drinking is proved only by the confession of the convict, but he retracts his confession before execution of had, so it's allowed. Tapi dengan syarat dia kena retract sebelum execution of the had. Okay, next. Okay, so they quote cases ni. MST Zubaida Begum versus the state, where it stated here the retracted confession in Islam has never been made the basis of conviction against an accused person. So bermakna there also accept retraction. When you retract the confession, you cannot execute hard punishment. Okay. Muhammad Nasir versus the state. Confession in order to be effective must not have been retracted. Again, if it is retracted before the execution of the had sentence, the sentence shall not be executed. So retraction kalau ikut Pakistan kena before had sentence dijalankan. Okay, next. Okay, Arif Nawaz Khan versus estate. According to the narration, when Maiz felt the intensity of the rejam punishment during stoning, he tried to escape. For those who were deputed for the purpose, followed him and continued stoning him till death. So when this incident, the Prophet asked, why did you not let him go? So dekat sini, Prophet kata, the fact that dia escape tu sama dia macam dia retract dia punya confession lah. Okay, next. Okay. So ini retraction in zina is the sole right of Allah. So ini section 9 subsection 1 offense of zina 1979. No had punishment can be enforced if the convict retracts his confession before the had or such part is enforced. Okay, so ini kalau zina, kalau in retraction in theft or robbery, this is a combination of right of Allah dengan individual. Offences against property and enforcement of hudud ordinance 1979. Cases in which had shall not be enforced is section 11 subsection 1A. When theft is proved only by the confession of the convict, but he retracts his confession before execution of had. Sama juga. Okay. Maknanya there is no had kalau you retract before execution of the punishment. Okay, next. Okay. Some case Arif Nawaz Khan versus the state. In Islamic law, so far as retraction from confession is concerned, it has two aspects. If an admission is made in respect of an individual right, it cannot be retracted by the maker of the admission against himself on the principle a man is caught by his admission. If it is made in respect of the right of Allah, it can be retracted. Sama juga melibatkan hak individu, hak orang lain, you tak boleh retract. Kalau hak Allah, you boleh retract. Okay, next. Okay, kita dah settle Pakistan, now kita masuk Brunei pula. Sikit je lagi. Okay. So Shariah Court Evidence Order 2011 Brunei. Definition section 20. Maknanya orally in writing or gesture. Sama juga macam kita. Effect of Iqrar section 21 subsection 1. Iqrar made by the person is binding on the maker himself. Iqrar outside court can only be admissible if made before two witnesses who are adil. Next. Okay. Subsection 3 pula kata representative Iqrar in proceeding on behalf of the person granting that representation made before judge is admissible. So sama juga you kena buat dekat depan judge and kalau dekat luar judge in front of two officers. Tengok yang subsection tu tadi, yang the slide before tu. Two witnesses who are adil. Okay, next. Next slide. Okay, bawah tu. Section 22 tadi. Naik atas sikit. Okay. Iqrar is final proof on the person making Iqrar and not proof against any other person. So maknanya kalau you confess, dia mengikat diri you, tidak mengikat orang lain. Okay, next. Okay, conditions of Iqrar. So the person making the Iqrar, section 23. This is the same as section 17. Okay. So yang subsection 2 tu is covered by section 18. Okay. Iqrar by minor lunatic wadi not admissible. Iqrar by minor who has been authorized by wadi to carry on business or so and so. Okay, next. Okay. So subsection 4, do the Iqrar solemnly. 5 shall be acknowledged and identified. 6 shall take note of the matters in his Iqrar. 7 not mahjur alai, not bankrupt. 8 made by a dumb or deaf person is admissible if he can write or sign, which is can be understood except in good cases. Number 9, under circumstances of maradul maut concerning the right of another person against him is admissible. Okay, lagi. Okay. So keduanya, person who benefits from the Iqrar. Okay, this cross-reference section 23 subsection 4. Not necessarily akhir dengan balik. So it's quite similar dengan kita punya. Sirah pun section 23 subsection 5 absolute and voluntarily. Subsection 10 pula not to be made during the state of intoxication for cases involving hudud. Okay, next. Okay, Iqrar in zina cases. Sikit je lagi. Section 24, the accused may be punished or conviction by had if the Iqrar is made before the court, made orally, clear stating the commission of the offence indeed made on 4 separate occasions. So this is embodied in section 124. So retraction can be withdrawn before conviction, after conviction, but before the implementation of the punishment or during the implementation of the punishment. Kalau ikut during tu bermakna kes Maiz lah. So hudud will not be imposed. Subsection 2. Next.
Habis dah, Madam.
Oh, dah habis dah? Okay. So nanti you tengoklah dia punya contribution yang subsection 2 Okay. So we have covered Malaysia, we have covered Pakistan, we have covered Brunei. So apa ni, Iman, ada soalan tutorial ke pasal ni? Pasal comparison, ada ke?
I think ada je.
Ada. Okay, so kalau siapa-siapa yang ada dapat soalan ni, this is how you should answer. Okay, you kena compare tiga-tiga. Boleh? Nanti Alia tolong share ya, Alia dalam group chat Okay.
Alright,
So
Madam.
can you take picture who attended kita punya lecture? We have 46 people.
Dah, Madam.
Dah ambil dah. So thank you. Nanti I'll see you on tutorial. So next week siapa nak present? Alia? Monday?
Monday ikut slot yang drag hari tu Madam. Sepatutnya present hari tu tapi macam yang tak hadir hari tu.
Oh, so yang hari tu is 2 orang kan yang tak hadir kan?
Ya, macam ada soalan 15 still belum 15 tu dah soalan 11 macam a few lah soalan 13.
Oh, tu belum lagi masuk syahadah kan, still Iqrar lagi kan?
Ya, betul. Confession.
So kita dah settle Iqrar, so on Tuesday we'll cover syahadah insyaAllah. Okay?
Okay, Madam. Alright.
Okay, thank you. Bye-bye.
Bye, thank you, Madam.
Thank you, Madam.
Bye, Madam.
Thank you, Madam.
Thank you, Madam.
Madam.
Enjoy your holiday.